thank you all for being here. I really appreciate that. And let me introduce the topic here is obstacles and impediments to reaching a FRAND license. So we have from the audience's left, starting, we have Matthew Osborne, and Matthew is a vice president and of GE Network Technologies, and happy to have him here. You were volunteered to be here by a mutual friend of ours, and we really appreciate you accepting the invitation. He is a seasoned technology counsel with a comprehensive background in licensing, SSO, SSD policy, FRAND principles, antitrust matters, acquisitions, and more. And next to him, we have Jim Harlan, and Jim is Senior Director at InterDigital, and he joined InterDigital in 2015, and he currently engages in mobile licensing, representing InterDigital before potential licensees to negotiate offers that have FRAND terms and conditions. So Jim, thanks for being here. Been trying to get you on a panel for a while. I'm glad it finally worked out.
Yeah, COVID got in the way.
Yeah, it got in the way of a lot of things. And we also have Curtis Dodd, and Kurt is Chief Intellectual Property Officer at Harfang IP, and he is a veteran of the patent monetization landscape. He works in enforcement and portfolio management, primarily in the telecommunications and consumer electronics space. So thank you all for being here. What I'd like to do is have you preliminarily, if you can, when I told you I wanted you to be on this panel titled Obstacles to Reaching a FRAND License, what was the first thought, the very first thought that went through your head that you want to just share with others? Because usually in my experience, when people agree to be on a panel, they have that moment where, yeah, sure, I can be on that panel, you know, and then it goes to, and I want to say X. So to kind of prime the well,
sure.
What is that X? Jim, you want to go first?
Sure, yeah, I'll go first. So I think when an obstacle and impediment to negotiating FRAND deals, or just even the concept of FRAND, is just, in my mind, it's been the number of new entrants into this industry. So I'm in the telecommunication, video coding industries, InterDigital, publicly traded. You can look us up on NASDAQ. And so in the last 5 years, maybe 10 years, we've seen more government agencies involved, whether it's antitrust authorities. I heard the other day that prior to about 10 years ago, there may have been a couple dozen antitrust authorities throughout the world. Now there's like 144. So antitrust gets involved because standard essential patents and SDOs sort of cover the space of industrial policy. And so with the heavy hammer of an antitrust claim, usually treble damages, that's an opportunity for money. So especially by government. So you have that. You have the new entrance of governments. Then you also have the new entrance of participants of SDO. So I think there's some folks here from the automotive industry. You know, there's this convergence. They're talking about the car being just a computer on wheels now. I remember not too long ago, Kodak was the predominant camera technology. There's some Canon, Sony cameras up here. I don't see any Kodaks though. And
are they still in existence?
Yeah, it's still in existence. It just doesn't sell film.
And it's funny, they actually invented the digital camera.
Yeah. It's remarkable.
Yeah, that is a cautionary tale of
Sure.
what you should not do and what you should do with your IP.
Sure, yeah. And I'm a former BlackBerry myself, so another cautionary tale. That's a whole other story. There's lots of videos and movies out about the BlackBerry story right now. So the notion of new entrants, I think, is another thing that sort of is an obstacle and impediment, because not picking on the automotive industry, I used to work for GM and Chrysler up in Michigan many, many years ago as a coder. But they're used to a particular model, right? If I have a BMW and a Mercedes, my braking system isn't the same. It's not interoperable between my Mercedes and my BMW or my Chrysler. They're all uniquely designed per product and even per model most of the time. I can't go buy brake pads and there's just the same one single brake pad, right? There's ceramic, there's all sorts of different types of brake pads. Brake pads are not interoperable. So the idea of interoperability, I think, is new for that industry. So when you come over to the telecom space, that's what we're all about, is interoperability. I pick up my iPhone, the Samsung, my Huawei, whatever device, and I'm just going to assume it's going to work on the network. So that is interoperable. So I think the new entrants coming in and them sort of, especially in the EU, the automotive industry is such a heavyweight powerhouse economic force that they have a lot of power. So the new entrants is the other thing, I think, is just sort of creates an obstacle, an impediment to just FRAND negotiations. I'll pause there.
Okay, great, thanks. Matt, your preliminary thought, and maybe explain why it was that you wanted to be on this panel or willing to accept the invitation. Because when I invited you, I remember you kind of seemed like, yeah, I'll do it, and then you got really excited. So what is that you want to share?
Yeah, so one of the hats that I wear at GE and as part of the GE licensing group is I advise our commercial teams on bilateral FRAND negotiations. We're a pool participant, but we also do bilateral deals, and something that I've picked up on, I think, that is where we get into places where there's a disconnect between a patent holder and a potential customer. I think it's just because we're coming from different places, different perspectives. So I think it's great that you're having, this week of discussions, because I think being able to speak freely about FRAND really will maybe help us understand each other's perspectives and be able to get to deals without other forms of dispute resolution. So when I think about, our perspective as an SEP owner, we're trying to be a fair and honest broker. We're trying to partner with our customers. We are open and transparent with them in our discussions, using objective data points, as most FRAND licensing programs do. We think about FRAND sort of not as just a range, but it's more of a continuum. When you start out a new program, there is no discrimination because you don't have any customers. So there's a wide range. And we like to join pools because that sets the low end of the range, and you have a wide range there. As you develop customers, it's sort of a sideways funnel, comes down, and then theoretically at the end, when you get your last customer in your market, it should just be a formula, and you should just figure it out. So as a patent holder, it seems that there should be, it's pretty straightforward, maybe even obvious, how these deals should be constructed and what your offer should be and how you make a FRAND offer. So then it gets very frustrating when the other side comes out completely out of left field, say this is not a FRAND offer, has all these different arguments, and it sort of feels like our future customers are using a different definition of FRAND than we are, and sometimes it feels like FRAND to some implementers means free royalties accomplished by never-ending discussions. Now, I don't think that's the case. Maybe for a handful, but I think most of our customers, they just need to understand where we're coming from and understand why an offer is FRAND and those kind of things. So I think most people are honest brokers, but what's the perspective of the customer? The customer doesn't have the rules and the restrictions that we have in FRAND. Their goal is to get the best deal for their client. That's it. That's the only thing that they have to do. They don't want to be at a competitive disadvantage by getting a bad deal. And so that's where the disconnect comes from. They'll look at, just like you can do with statistics, you can make any number, anything work if you manipulate data points. And if this isn't in bad faith, this is what their job is. So they'll look at number of patents versus patent quality, if it suits them. They'll look at number of families versus breadth of a portfolio and depth of a portfolio, if it suits. They'll look at, and Gene, you were talking about this yesterday, sort of like the buffet of options of terms, and they try to make their own plate, instead of what truly is discrimination is, you want to take the same plate that customer already got. And actually, we had a case in Munich earlier this year where the judges said, if you really think you're discriminated against, you should be willing to sign the license of the company. You should point to a company, point to a deal, and say, I'll sign that deal.
Right.
So I think that disconnect and understanding that disconnect, if you can convince your customer that you actually can't do the deal that they're trying to make you do, because you'd actually be violating your FRAND commitment if you take some of these deals from from the licensees, the initial ones, because you'd be discriminating against your current customers. If you can get past that disconnect, then you can get to a deal. But that's usually where things stop and get held up.
Yeah, and I want to come back to that because it also seems like there's a lack of transparency in the industry, and we heard this a little bit in a different context from Dave Kapos yesterday, who he was talking about how, you know, if you're the one that creates the problem and the impediment, you can't really complain about it. And I mean, there is sort of a sense in this is, you know, if you where the child goes to court and throws himself on the mercy of the court and says, I'm an orphan. And the judge says, well, yeah, but you killed your parents, so you can't really play the orphan card, you know? And it seems to me that there's some of that goes on where we don't know. We want you to prove that this is FRAND, and they know that you can't because they know that they and all the licenses that they come up with demand that it be kept confidential. So they know that everybody else that's already signed a license has a clause like that in their agreements with you that you can't tell anybody else anything. You know, so you can't create the problem and then cry about the problem. And there's all kinds of legitimate business reasons. I'm not saying that these things should be open. There's legitimate business reasons to keep them private, but then you can't complain about it when it is private. We'll come back to that. I think that's a bigger issue here, but thanks, Matt. And Kurt, last but not least, your preliminary thoughts here on what's the impediment.
Sure. Just the first, I want to say thank you, Gene, for including me in your wonderful panel discussion here today, and Renee for all your help, and Eileen. I know she's not here today, but
she's listening. You can say hi, Eileen.
Hi, Eileen. Thanks for all your help editing my. I still use 2 spaces after a period, and Eileen fixes them all for me. The major impediments. I'm going to come at this from a different perspective, slightly from my esteemed colleagues here, because I'm not working for a public company. It's a smaller, privately held company, monetizing discrete portfolios. And the makeup of the portfolio is primarily in the United States. So building upon the sessions we've had in the past few years, Gene, going back to the pandemic days, really taking this on and focused on the different remedies that are at issue here, damages versus the injunction, and also from a contract standpoint, because it seems like contract law is what really matters most when it comes to FRAND in the United States, whereas in other places it's largely driven by antitrust concerns. I think the major impediments are, frankly, there's a misinterpretation of patent law, contract law, the language of the contract itself that's governing here, the letter of assurances, and antitrust law. And such that it provides, as Judge Michel was saying yesterday, very little incentive for anybody to do timely licenses. And I'll give you some specifics here. First of all, you have this interpreting of the contract such that it applies to releases for past infringement. Again, if you look at the language of the ETSI letter of assurance, it says you're prepared to grant licenses. Licenses speak to the future. So why is it that there's any consideration of what should be FRAND for past damages? And this idea of capping damages really is another way of saying you're not going to get damages for willful infringement. And this is something David Kapos mentioned yesterday that he had written a paper on, and I believe that's a very important point is, look, if someone chooses not to have a license, that's fine. Whether they can still get a license for going forward, that's a more complicated decision. But there's nothing in the language of this agreement that says you should be giving a release for the past. If somebody chooses to infringe without a license, that's on them. You also see a shifting of the burden of proof, especially on this issue of essentiality. We heard reference many times this morning to these different policy statements. The draft 2021 policy statement said something to the effect of there's nothing wrong with the implementer challenging essentiality. Well, there is to me, because if there's no essentiality and the burden of proving essentiality is on the person raising the obligation, then there's no obligation to license on FRAND. So we call this having your FRAND cake and eating it too. And we're seeing these concepts now finding their way into things like the proposed European regulations. Another one I think that John was going to speak to, because I know he spoke a bit about it last year and I believe was going to be the subject of the opening presentation today, is, you know, what does it mean to be FRAND? It's again, there's no reference to FRAND rates in the contract. It refers to FRAND terms and conditions, and his point is, well, what's fair and reasonable is really a function of when you do it. And the analogy I gave last year was, if you're going to bet on the World Series in April, the odds are one thing. But if you wait till October and you know who's in the playoffs, the odds change. As long as everybody's being treated the same in that way, it's not necessarily discriminatory. We also heard yesterday, I think all the panelists saying that they felt one of the major impediments was the lack of the injunction. And I think that's a little bit of an oversimplification, because it doesn't explain the FRAND issue. I think it's really one of, under U.S. contract law, there's an obligation to cooperate on the part of the party to whom the obligation's owed, if it's something that requires cooperation. Gene, I heard you say yesterday, well, why don't we just put an obligation onto the implementers? Well, the problem is the implementers aren't a party to the contract. So you can't put...
Ted X, he scolded me for saying that. Ted's not here yet, I don't think.
I think you have to look at it as it's an implied condition that it comes prior to the obligation of the patent owner that you be cooperative, such that if you don't provide that cooperation in a timely fashion, then the obligation is discharged.
Right, but what I think you could do even better than that, though, is because the implementers are not a party, wink, wink, nod, nod to this contract, is if they don't play any role in standard setting whatsoever, nobody cares what the implementers can or can't actually physically pull off, right? Which is just, it's not true. I mean, there is a lot of thought that goes into whether this can be pulled off versus something else can be pulled off. So let's wink, wink, nod, nod. They're really not considered. They're not a part of this. They're not privy in any way. What if I were running the SDOs or SSOs? What I would do is say, okay, you guys have to promise to offer FRAND. Now, if the other side does not engage you in a good faith, fair dealing way, then you've satisfied, from my perspective as an SSO, your obligation and release you. I mean, there's no reason. I mean, you clearly have a relationship with the SSOs. And the SSO is then sort of assuming, I suppose, that the implementers are the third-party beneficiary of the agreement that they have between you and them. So why can't they do that? Why shouldn't they do that? I mean, I'm not a big fan of the SSOs setting the FRAND rate, because there's so much that goes into the actual number, which we'll talk about here in a little bit. But, and we don't want a bunch of technical geeks like us, crunching the numbers and getting them wrong, right, mistakenly or otherwise. But I do think that they could level the playing field more. Would you agree with that? Maybe I'll ask all of you that.
Yeah,
to the extent that you can make a comment on that. As
thoughts.
I said I was going to ask all of you that, then I thought to myself, well, maybe you can't actually say. But if you can, do you think that that's good, bad, or indifferent? Am I off in left field?
No, Kurt actually brought up a few things that are on my soapbox for like the last decade probably plus, is that this notion that it's that you're prepared to grant a license under ETSI, and not only ETSI's policy, but under the common patent policy of the ITU, ISO, IEC, which covers HEVC and different video codecs. So there's this notion of being prepared to grant, and there's also this notion that FRAND terms and conditions, there's no such thing as a FRAND rate. That entered the vernacular probably in the last 5 to 10 years, and it frustrates the heck out of me, because you can honestly have a $0 cross license that's FRAND. There's no rate involved. There's terms and conditions. There's maybe a JV that resulted in it. But there's but the notion of a FRAND rate, I think, is kind of nonsense. But you're going back to this idea that, what is FRAND, and it's kind of, I like Matt's free rates or something like that, or something that was kind of cute. But it's great. I remember back in the day when Microsoft was arguing that, oh no, it's not a contract, there's no terms and conditions, there's no four corners of the agreement, blah, 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 blah. Then they got involved in a Motorola lawsuit, and now they're like, oh no, it's a contract, we need to be the third-party beneficiary of the contract. And then so you see this pendulum swing from one side to the other, and it goes back and forth and back and forth. And right now, we have certain industries at odds with other industries. Fast forward maybe 10 years from now, they might be flip-flopped. Who knows when you have automation in automotive vehicles where that's going to end up. But this idea that FRAND's not defined, I think That's been born out of in the 90s with Etsy and all that. Here in the States, it's RAND because we get rid of the fair part. Things are, I guess, are not fair in the U.S., but they are in the EU. However, when you do, sit down, and these are all great ideas, but one of the things is, okay, now making that change. So I've been involved in the IPR committees at Etsy and ITU, and they're consensus-based. Consensus in those standards bodies mean lack of sustained objection. Well, at the IEEE, it just means more than 75% or majority, and or supermajority. So you have different SDOs with different definitions. The last thing I remember us ever being able to change at Etsy was transferability of declaration. So you declare to a patent, it transfers to the subsequent purchaser. That was probably 10 years ago we got that passed. Just nowadays, these are all really great ideas, but it's hard to have the SDO change, so something else might need to change. To your point of, well, implementers aren't part of the agreement. That's true. So let's have maybe, as an alternative, application type standards. So you have Etsy as a technical standard. Now let's have a 5G pool, let's say, where implementers and innovators join that pool, and they all agree to be bound by XYZ terms, and only as a member of this, I call it a pool, it could be something else, then they're bound by the terms of those agreements. But until you can pull in implementers into the equation, it's always just going to be a slog, who can outlast the other, until finally, hopefully, to the premise of your statement in the program, most of these agreements, do get signed. They don't result in litigation. They don't result in arbitration. I would say 95% of the agreements, are agreed to. They just might take a while, but at the end of the day, they do. It's just the ones that don't that you hear about.
Right. And it's, yeah. And
there's a lot there.
Well, there is a lot there. Let me just ask you this before I ask the other guys to react. What I have heard, is this correct, incorrect, or more complicated and needs explanation, but that the ones where you don't hear about the deals actually happening that make the news, and those dwarf in size the deals that are actually done in arm's length because of the players that are involved.
You mean the monies or the?
Yeah, more or less the money. I mean, and also it would be in terms of market share and all kinds of other things. But the players that are out there who are not engaging in the arm's length negotiating that is envisioned really, and force the lawsuits to happen. And there's nothing wrong with a lawsuit, right? You get posturing. But when it's lawsuit after lawsuit, appeal after appeal, lawsuit after lawsuit, and you're half a generation and you still haven't gotten paid on 3G or something like that.
Yeah, Ringo, look at them.
Yeah, I mean, those are the implementers that are the really biggest ones, right? That are doing that. Is that fair, or is it
reasonable, not discriminatory?
Yeah. Am I overgeneralizing?
I think so. I mean, I think that I think it's an overgeneralization because you do hear of deals getting done. I mean, our company, there's a lot of public deals that get done that are publicized. Same thing with some of the companies in the audience. It's just, I think that when things are more contentious, those are the ones that when people dig in and they're obstinate, whether it's both sides. I mean, it's, I can be a jerk just as easily as the other side can be a jerk. But it's hopefully at the end of the day, you sort of reach your hand across the desk and you say, let's do this deal, and it gets done.
Okay.
Yeah,
Matt.
One of my examples is, GE. We have a big video portfolio. We're a member of Access Advance. You might hear about our litigations, but we have less than 10 litigations that we've done on the video portfolio. We have over 300 licensees, and that's through the pool and bilaterally. But you don't hear the number 300. You hear about when a case that's gone pretty far in Germany might settle, or different things like that. So there are a lot of deals that get done, and those deals tend to be the SMEs that just want to, settle up, be compliant, move forward, and get their products out in the market.
Mm-hmm. Kurt, what's your experience there?
Well, I'll just add to what I was saying earlier again, that these misinterpretations of the law that are now finding their way into regulations and policy statements and things like that, they disincentivize acting early. In fact, I'll go a step further and say they incentivize holding out, because you can, infringe and generate money from infringing, and now use that money to fight against the need for licenses or bring IPRs and so forth. And so the analogies I use here, it's like, imagine if you have a public parking spot, so anybody can access it, and if the fine was no more than the fee, and they're not going to put a boot on your car, and the city can't even penalize you for forcing them to have to sue you. Who would ever pay that parking, especially if you can take a food truck there and profit from doing so? And so that's kind of the situation we find ourselves in. If there's no downside, if you're not going to face treble damages, you're not going to face an injunction, there's very little incentive to do a deal. In fact, there's an incentive to hold out, because you're probably, you could do better in the long run. The other example I gave is just take your typical sale of goods arrangement, right? In this case, think of how bizarre this contract is. The obligation is on the party that's already handed over the goods. Now they have an obligation to get the person who has the goods to pay, and they're not a party to the contract, so you can't even sue them for not paying. I mean, it's just not workable. There's just no incentive there. So I liked your point yesterday, Gene, in the copyright world. There are penalties associated with not paying for copyright if you use that. It's not just that you have to pay the fee later. You can be penalized.
And there's also attorney's fees. And you say that, and people say, oh, well, you get attorney's fees. No. In copyright world, you get attorney's fees. This is not like a pie in the sky, in patent litigation.
So like the English rule or whatever.
Yeah, it's not quite the English rule, but it is. It happens. When was the last time you really saw it happen in our space? They're available all the time, right? Mm-hmm. And maybe it's because fundamentally in a copyright infringement case, you have to prove that there was copying. And you can't you can accidentally copy, but those accidental copying cases don't find their way to court. A judge is not ruling on somebody, oh, geez, I didn't know, I'm sorry, I don't know how that got in there, a cut and paste error, or whatever. Those things get resolved. When you go to court and you lose in a copyright case, it's because you, Kurt, purposely copied what I was doing, didn't want to pay me, wanted to make money on it. Okay, well, maybe that's why there's...
I was just sampling.
Yeah, I was just sampling. Yeah, you were sampling. Yeah, that
80% of the song.
Yeah. No, I know. So, it's different in other areas. It's just a different
I'd
experience.
submit to you, there's no other licensing regime in the world that works like that. If you want a fishing license, Gene, you got to pay for an advance. The government doesn't have to prove to you how many fish you caught and their right to do this and all the rest of it. You might not need that license. You might not catch any fish, but this is the fee. And if you don't have the license, you get caught. Here's the penalty, and that's what incentivizes people to get the license.
I think some of the judiciary around the world is starting to get it. And in our case, in Munich, C4IP Council, or 4IP Council, has a good summary of it. I encourage everyone to read it. The judges said that timing matters. You can't, if you go all the way into litigation, then say you're discriminated against someone that signed up without litigation. You can't wait years and then say, well, I want the same deal that someone got that was your first for your first customer, your first licensee. So I think judges are starting to get it. They need to get it, and they need to understand that for the system to work well. Bigger companies, we can weather, litigation, waiting to have customers sign up, but it really hurts the SMEs, and that's really a problem. The small entities that really need to rely on their patent portfolio for survival.
Yeah, and a lot of times it's SMEs, even on the product side. I liked what Kurt was saying about the sale of bill of goods, which made me think about supply chain, bill of materials, and creating a product. So when I was at BlackBerry, and I'm sure other OEMs do this, there was actually a line item for royalties that we knew that, hey, we might be paying 10 to 15% of the total sale of our BOM is going to be intangible royalty. And so to have these SMEs that sort of bake that in and understand that, look, you know what, I have this drone or whatever object I have that I'm creating, getting all the pieces of like a puzzle together. Part of that piece of the puzzle I know is going to be a cellular chip. Maybe I should set aside 10% of my BOM to the royalty rates, and then reach out to licensors. That's a great model. I mean, it's something worth admiring, and it happens from time to time. But the problem is there's so much FUD out there, fear, uncertainty, and doubt, that is sort of like people just go off and build and build and build and create, and then they get upset when licensors come knocking, without considering, that maybe we should have set aside a little bit for the IP that may have gone into the product that enables it.
Well, let me stop you there. Do they need to set aside anything? Because when I see these, even when you see the big verdicts, and even if the big verdict sticks, I never see an adjustment upwards of price.
Yeah, it's sort of like credit card companies, right? I mean, they never sort of like cut you a break.
Right.
Yeah, there's no adjustment. Yeah, I mean,
and so when they're complaining about, we just lost $1 billion, but they absorb it. They don't raise their prices, or I mean, it's like what does that tell you? I mean, maybe they maybe have been doing the responsible thing behind the scenes, and they have like a little account there to handle for the anticipated problem, right?
Sure.
Or maybe they were just so significantly overcharging everybody that, it's no big deal. It's just a rounding error now.
Yeah, right.
But the Federal Circuit doesn't treat any of this like it's a rounding error.
No.
You have the word B involved, the billion number, and you get a different level of scrutiny. You'd be better off winning 999 million, so that way you don't have to deal with the billion. And that's just wrong. The math is the math. I mean, maybe we could ask each of you to talk about that for just a minute, not to do math or anything, but we're talking about with the standards area, billions of people that can be using these standards in various devices. And many people, like we probably, you see what I have up here, and people probably have multiple devices right now that are capable of in their pocket or in their bag, on their wrist, of needing certainly 4G, but likely 5G as well, right? So there's billions and billions of devices out there that need this. So what is that done with the math, and what goes on in the negotiations when that number, there's just the multiple, the X, the simple third grade multiplication gets so high. I mean, is the other side telling you, well, good luck winning that? Despite what the math being what the math is. I mean, how does that dynamic play out?
Yeah, it's kind of a distraction, like the high level number, because the rate's the rate. Like with the pool, the rate is the rate, and congratulations that you have to pay such a significant royalty because you're doing so well, right?
Right.
You're good for you. If everyone's treated fairly, it should just be a formula. And I think we get distracted by these different ways of phrasing it when it really just comes down to what's the per unit rate, and what are the terms that are adjacent to that, and how does that work? And if you get these big companies that we never had in the past, these huge companies are doing so well, good for them. But that's just how the math works, right?
Right. Kurt.
For us, it's an interesting problem because we're taking on smaller portfolios that are typically owned by operating companies like ZTE or Korea Telecom or what have you. We don't know what they've been offering them for themselves and things like that. If we can get a bunch of smaller companies to sign up first, like we did at YLAN, and that sets a rate, that's good. But it's a lot of work to get all these small deals done first. But it translates well for if the big guy goes last. If the big guy goes first, that's a good problem to have. That you're getting most of your money early, but now you got to deal with this problem that if you divide that rate for everybody else, it goes way down. So the big part of it is these volume discounts. I don't agree with the English court just throwing them out. I mean, they're used everywhere, right? If you've ever been to Costco, you understand how volume discounts work. They're used in pools, they're used many other places. You take that out of the mix, then it becomes more difficult.
Well, it's interesting you say that, with pools, because I've seen pools where they'll set up and they'll say, okay, here's the rate. We're publishing our rate. These are the patents. These are the players involved. And this rate is guaranteed if you take a deal between now and the end of the year. Next year, it's going to go up 10% or 20%. I've seen them say this, you know.
Early adopter discounts.
Early adopters get a discount. I mean, and I don't understand why that is difficult for people to understand. I mean, you know, have you never bought a ticket to anything in your life?
Yeah.
You know, when you buy a ticket early, the price is cheaper.
Right.
It's like
You know,
Kickstarter, right? You
Right.
know, if you go in early and you're not even sure if you're going to get the product, I don't know if this is going to be a success or not, but I'm going to get in early, you get a discount. And then
Right.
when it's a wildly successful product or something and you want to buy in, it's twice the price.
Right. And when you buy like season tickets to anything, the price is either the price is lower or the seats are better, right? Because you're buying more. I mean, you're buying in these are just business sensible, business responsible ways of engaging with a seller and a purchaser. And it seems a lot of times in this space that those business responsible, tried and true marketing 101 doesn't not get considered. And I don't understand why that is.
Well,
Is it because the numbers just get so big and people gloss over?
I think it's just you have a bull in the china shop sometimes in the case of like England. They're just reading in all these things into the commitment that aren't there, that, you know, you don't have to take a license until 10 years down the road. But if you agree to what the English courts will decide are the rates, then you could still have FRAND, but we're not going to tell you what they are. And it doesn't say any of this stuff in the contract. So when they start doing things like just say, oh yeah, volume discounts, you can't have those, or early adopted. Actually, I think they were okay with the statute of limitations going back further, but I don't know why they're coming up with these things. But it just adds more confusion, and again takes away, you know, makes impediments to getting deals done. And I'll add one more thing, which is again working for a small medium enterprise, trying to license discrete size portfolios. We're typically doing lump sum deals. And they're that much harder to try to make line up. It's really difficult to make running royalty agreements line up for the different players, but we don't know what the volumes are going to be. So you have a lot more of these disagreements over what the future might look like, and there's just no way to know, which is another
Well, to the
impediment.
lump sum notion in your comment earlier about smaller deals than the big guy. Well, if you think about those smaller deals probably aren't going to be comparables to the big guy, right? Because they're going to say, well, you sort of cut these deals to get to us. so you're going to have to almost start fresh with the big guy. I'm just assuming the long tail model.
That's what Interdigital Lenovo, the courts are saying, right? They're basically discounting the interdigital deals because somehow you had leverage. But I'm curious to see.
I'm not free to comment on that right now. But yeah, so it's no comment.
Yeah, that's fine. We all understand there's certain things that people can't say because if litigation is ongoing. I appreciate you're here.
Sure.
You know, to talk about this issue. And I want to go back to something that I mentioned, Matt, when you were giving your preliminary thoughts. I said I wanted to come back to it. And during our pre-call, we talked. You made the point that you know, if you're going to use a comparable rate, then maybe you ought to be willing. You ought to be required to be willing to accept that deal. And then I went the next step, and I kind of previewed that. It's like, well, and if you're going to complain about lack of transparency in any paper that you filed anywhere, then the deal that ultimately comes out of this case, the licensing deal to settle this, has to be, all terms need to be open. You can't require it to be private because talk about having your cake and eating it too.
There should be some kind of unclean hands application here, right? You know, everyone wants transparency. That's something any SEP holder always hears: transparency, transparency, and transparency. I remember when Interdigital published their transparency information and rates and all that information. It was in response to this big outcry. I was involved with that when I was at Interdigital. But you know, that the SEP holders are bending over backwards to be transparent. A lot of the time, I think it's a red herring. But the people that aren't being transparent are certain customers, certain licensees that once they get the deal done, and they want to know all your deals that you've ever done, and they want to know all the terms, but then they want their deal confidential. And I think a lot of the times, I'm trying to do a deal with a new customer. I would like to show them terms from previous agreements, but I can't because I have an obligation to my existing customers to keep that confidential. So we try to use our objective data points and speak as open and honestly as we can, and know that if we get thrown into litigation, we can back up everything that we've said. But it really does make it very difficult to get past that. If there's any distrust in the relationship, get past that where I can't actually tell you all about my other deals, because that's what the customers want. They want it buttoned up.
Yeah. Jim, do you want to say something?
Yeah, no, I was just sort of contemplating.
Should you say something?
Yeah, no, it's something else that
Okay.
both Kurt and Matt were saying, related to kind of value and pricing theory and this notion of the math that goes into it. And, earlier I said that one of the impediments or obstacles, and it's kind of sort of evolved now, but are just economists. When economists get involved, they come to the table with their own version of a pricing theory. What's the value of the technology? There have been some of the submissions that Chris was talking about earlier to the PTO, and some of the parties insist on, equating, I guess, the rates that licensors act with, what is the value of the patents pre-standard and post-standard is sort of the ex-ante and ex-post argument. I know Etsy promotes ex-ante declaration of rates, which I think Qualcomm, Nokia, and Ericsson tend to do. We did an ex-post when we did the transparency initiative, and but it's it just sort of, when it boils down to dollars and cents, it's sort of like, well, obviously licensee wants to get the best and cheapest deal. Licensor wants the fairest deal because they're bound by that requirement. And so it's, so you sort of come to the table in the beginning with asymmetries involved, right? You just have asymmetry negotiation positions and or asymmetric negotiation positions, and it's just it makes if you aren't talking the same language to start off with, it makes it that much more difficult. And then to Matt's point, yeah, it'd be great to show potential licensees our comps, but again, those are confidential agreements we have with third parties. Then again, we'd like to see their agreements with other licensors they've entered into, but that's hands off. They can't show us that. So if you can, it would be nice if people, like I said, if it just goes back to an implementer builds a product, they set 10%, 15% aside on the BOM for royalty rates. Now look, we've got 10% to deal with. Let's figure this out. All right, let's figure it out. So it's just a deal to be done, and it gets frustrating when you just get stuck on certain minutia where it's just you're so far apart, maybe 5, 10x apart, that that there's no light at the end of the tunnel until you either arbitrate or litigate.
Yeah.
So that's all I have to say about that.
Gene, if I can add something.
Go ahead, Kurt, please.
I think part of the problem, step back now a layer as well, and Jim mentioned language being important, and I agree. I thought it was a very interesting point yesterday from the first panel saying that because, let's call it the implementer crowd, or the implementer-leaning crowd, let's call them, didn't get what they wanted from the courts, they've now ramped up the propaganda campaign and going to the legislatures, and you're seeing a lot of terminology. They're not legally defined terms, but people act as if they know what they mean. Transparency is a good one. We've talked about this, Gene. The patents are public, the standards public, the prior art's public. There's been a lot of announced rates. There's all kinds of stuff that's public. It's really about who's supposed to do the work, who's supposed to figure out how many essential patents do you have relative to the whole universe. So transparency is one. Hold up is another sort of dog whistle term. Two that I particularly hate are when people say patents are declared essential. They're not declared essential. They say to the extent they're essential, I promised a license, but they're not declaring them essential. And then you also hear this term over-declaration, another made-up term, all these things. And the high watermark I see is, for example, in the European regulations, and they talk about the power of an SEP. They say when you have an SEP, you can either force people to pay as much as you want them to pay or shut them down. Well, What about option number 3, where they just use the technology without a license and force you to chase them for a decade? I mean, how can they not acknowledge this? And now, most recently, you see the SME, all this concern for SMEs. My experience has been the SMEs tend to find themselves more on the innovator side. I don't know if many SME car companies or SME phone companies, but now you're seeing, again, this big initiative to try to make life better for the SMEs. But I'm not sure there's a problem there. And even if there is, why aren't we waiting to see if the industry comes up with a solution like it did for Avanci? It smells more like astroturfing. And I say this because if you look at the submissions that were made in response to the agencies asking for input on all these questions about SMEs, the people that responded were Cisco, Microsoft, Apple, Dell, and all these big companies raising their concerns. Where are these SMEs that are waiting to implement this technology? It just doesn't seem believable, the narrative that somehow there's all these small companies out there that really wanted to implement technology, but they just can't sleep at night because they need to have that license in advance, when we live in a world where, up until now, people just implement the technology and deal with it down the road.
Yeah.
And we talk, usually when we're talking about these issues, we talk about cellular, like 3GPP, we talk about stuff going on at IEEE, and we talk about video at JVAT or ITU, right, ISO. But there are also smaller SDOs, and we participate in the Wireless Power Consortium, and there are a lot of SMEs there, right? And they work with wireless charging for proprietary solutions, but they like to incorporate the standard, and they're contributing to the standard. It's a smaller SDO, and they're on the innovator side. They need strong patent rights to be able to monetize their research. And so, when we talk broadly about these different issues that hit the big SDOs, we might lose sight of the smaller ones where the SMEs actually are practicing and participating. And they just basically have to deal with whatever happens at the bigger ones. Whatever the policy prescriptions are that come from 3GPP and IEEE, it filters down into the smaller SDOs and the smaller programs, and they're just kind of stuck with it. Mm-hmm. They don't really have a voice. It's unfortunate.
So we've identified, I think, a lot of the problems and a lot of the reasons that there's issues there. How do you break through to still get a deal done? So in the cases where deals do get done, and particularly maybe we could, let's focus on the ones that don't require litigation, because that takes on a whole new life of its own, and there's posturing, and maybe they push you into litigation to get a better rate or more favorable terms or what have you, and then they sign a deal, and then sometimes they go into litigation, and we're never going to sign a deal unless we lose every challenge. So before we get into the litigation world, how do you get past the posturing that inevitably has to happen in any business negotiation to get to the heart of the matter where both parties are ready to put ink on a page?
I feel like there's a point where, and it's hard to describe, but I think most people in the business feel it when you reach this point where the posturing stops, and that's because of trust between the parties. If you develop a relationship and develop trust, sure, there's some things that I can't show you because I have obligations to my existing customers, and there's some things that you can't show me. But do you trust that everything I'm telling you is backed up by objective data points? And if you can develop that trust, I think you can get to, it just feels like now you're going downhill instead of uphill. And that either happens or it doesn't happen. I don't know how you can force it to happen. I don't think you can, but you can give yourself the best chance by just being honest and use objective data and try to develop a relationship with the person across the table, with the people across the table.
So my answer is more simple. Get rid of the lawyers.
Yeah.
I mean, honestly.
It's funny you say that, because when I did a thesis on alternative dispute resolution back when I was getting my LLM, and I went to Delaware and I interviewed like 3 of the district court judges, and they said, okay, the person you really need to talk to is our magistrate, because we send all of our cases to her to try and mediate to see if it can be settled. And I said that she at that point had mediated 700 plus patent disputes. most overwhelmingly very successful. And she said, "What if I can have in the room the person who is actually responsible for writing the check, the CFO or the CEO or whoever it may be, the case settles."
Yeah.
Yeah.
Get rid of the lawyers, because contentious lawyers will come to the table and say all negotiations are handled under the auspices or the shadow of litigation, right? So everything they do is in prep for litigation down the road. So it's letters are contentious, calls are contentious. Everything is about prepping for litigation. You talk to business guys, and they're like, "Look, this is such a distraction. I want to get the deal done. I can afford to pay you X," and you're like, "Well, I want you to pay Y," and then you sort of find a happy medium, and then you move on, and then they can go about their business. But meanwhile, you've got lawyers, whether they're in-house, traditionally external, that are charging by the hour, that are trying to do this, and now they have more and more clients, and especially it's just if you get rid of the attorney and the contentious notion, and you just try to work on doing a deal, and because at the end of the day, I mean, InterDigital, we're an R&D lab. Like, bringing up BlackBerry again, which I hate bringing up old companies, but I've done now 3 times. When we were going downhill, I know Alden's here. He's a former general counsel over there. He was in-house. Maybe he left. But, there you are. When we were decreasing, the first group that was cut was our advanced research lab. And our advanced research lab those are the guys. That's InterDigital. We're an advanced research lab. We're the only publicly traded advanced fundamental lab in the country. And so when you think about, if you think about there a lot of times we are the cost center. So we have to make up our revenue somehow. So the only way we can make revenue is by our licensing program that reads on the standards. So it's just, and once you talk to business guys, engineers, whatever, people that care about the product, they'll be like, "Okay, this is fair. You guys, you actually have more than half of your company engineers. You're reinvesting. You're sending your engineers back over around the world on a 10-year cycle, right? Cellular technology is a 10-year cycle. And we're making these core investments in 2010. Hopefully they pay out in 2020. So it's just like, it makes sense from a business perspective for business guys to be in the room, the guy writing the check, and once you can get the lawyers out of there, unless these business guys just want to throw down the gauntlet and trade blows, that's different. But I really think just have this be a business deal, and it'll get it done a lot quicker.
I agree with Matt and Jim on that, especially the trust part. I was going to say the exact same word, Matt. I have a neighbor who works for the United Nations, and part of his job is to go into the world's hotspots and negotiate aid deals, places like Kabul and Nigeria and things like this. And another friend asked him, what's the most important thing when you're sitting across from like the Taliban? And he said, trust. It's not a chess game. I'm not trying to win. He goes, any sniff that you're not on the level and it's not going to be good. And I feel it's the same way when we're dealing with would-be licensees. I used to see the in-house counsel as an impediment. I now see them as my best friend in terms of, my job is to give them the information they need, and hopefully it gets bubbled up to a business guy, and it's not becoming a battle of wills or who's smarter over this. Some companies, it's just inevitable. In my world, there's three kinds of licensees. There's the ones that just ignore you. Okay, fine. There's ones that meaningfully engage. We like those ones. And there's those ones that are going to use it as an opportunity to try to create breach of contract claims or antitrust claims again. Those are the ones that really bother me because they create the most work, and there's no hope of getting a deal done. But I do come back to this idea. It's really about building trust and having a certain threshold. And if somebody comes up with some good prior art, then we'll pull that one back and things like that as a way to try to build that trust.
Okay, so we have about 6 minutes remaining in the hour. Does anybody have any questions for the panel?
Thanks, Gene. Thanks, panel. We're talking about obstacles to getting a deal done. One that hasn't come up too much is the fact that the patents continually has a target on its back. I'm wondering if you guys have thought much about the concept of quiet title. I know there's some proposals out there on the topic generally. When I think about it, there are a lot of analogs, other legal doctrines that basically, in one way or another, say enough is enough. Whether you think of double jeopardy or statute of limitations or reasonable reliance or some of these other doctrines. Just wondering how much the fact that the patent's continually got a target on its back weighs into it.
Yeah, I mean, I think that, you know, that's just part of what we have to deal with in the current climate is that you have to, it's really tough to be a patent owner, right? If you make one mistake, your patent's gone, you have to do everything right. And that's just kind of part of the way it is right now. But I think courts are starting to realize that you can't, if you're an implementer, you can't just keep trying to invalidate and being a nuisance. And I think the patent office is looking into this. You know, if you're just continually doing it as a nuisance, judges are realizing that's a holdout tactic, right? That's an unwillingness tactic.
So I have split minds on a lot of these types of things, and that question brings it to the forefront. I fundamentally, although it didn't come up during this conversation, it did come up during our pre-call, and this I kind of felt like I rolled in a little bit of a grenade and it exploded. But I said, I get why implementers don't want to pay for patents that they're not using, right? You know, we have Tim Pullman, for example, has his AI-related software that goes through, and when they look at these portfolios, they say, yeah, it's usually around 20 to 25% of a portfolio winds up being the piece that each implementer winds up needing based on what they're doing, what they've included in the standards, and all that sort of thing, right? So in my mind, I was like, well, why do they have to pay for the whole portfolio if they're only using 20, 25% of it? Okay, so put a pin in that for a second. But then when it comes to validity, I'm like, so they have 40,000 patents in their portfolio. Even if you're only using 25%, that's 10,000. So you're going to challenge one at a time as if you're going to be able to knock out every one of the 10,000? And it's like, okay. I look at this and I'm like, look, this is a portfolio. You're licensing a portfolio. We can have a conversation as to the numbers, as to what you're including, and that should be part of I think the whole FRAND discussion. But if you want to operate, and I think this is part of the problem from my perspective. I'll give each of you the opportunity to talk, comment on this. When I get frustrated is I think that you know the implementers will make a good point, and then when the innovators then have to respond to that, it's never enough. It's like it just gets you to, okay, well, now that that's resolved, now I'm going to bring up something else. You know, now that I'm only using 1 in 4 of your patents, now I'm going to say the 1 in 4, all 10,000 of them are invalid. And if they're not invalid, then we're really not using them. Ignore my previous comment that I admitted that we were using them. You know, we're not really using them. You know, and it's like, Jesus, for God's sake, are you using the standard or not? Is this portfolio got standard stuff in it or not? You're not going to, and this makes it much more difficult in why we started where we started yesterday with the global policy conversation. Because you don't license the Chinese portfolio. You don't license the European portfolio. You don't license the US portfolio. You license the portfolio. And it doesn't, because it doesn't make sense for anybody to engage in those extra transaction costs, right? So how does this dynamic play out, and how do you break the cycle? Jim, first?
Yeah, so that's a really small question that requires a lot of time. But I think to a couple points is that, you know, this notion of essentiality, validity, and all that, and I get it, and you know, licensing a portfolio is industry practice. I mean, I think a lot of times you sort of rest on that laurel, is that industry practice, we license the portfolio, the entire portfolio, is point one. Point two is, you know, I get it, from a licensee's perspective, they want to license valid and you know, patents that read on the standard. And to something Kurt said earlier, essentiality can be mandatory or optional, and the ETSI IPR policy says may be or become essential. So a lot of times you don't necessarily know. You know, at our company, other companies, you don't just like it's not just a notion of submitting your technical contribution and then the provisional patent that sort of went along with it. There's a process, right? That contribution needs to be accepted and then finalized into the final version and frozen version of that, R18 of 3GPP or whatever. And then that patent has to go through its process through the prosecution and make sure the claims align still, or the patent office might kick something out. And then on top of that, under AIA, you've got another bite at the apple, if you will, of invalidating it. And so, yeah, to Brian's point, talk about latches. The one that gets me a lot of times is, why isn't there treble damages for intentionally infringing this patent? Because it's known, it's published, and all that stuff. But that, it comes up every now and then. It is tough. That's kind of why, this industry is kind of fun and turbulent and exciting and what kind of gets me up in the morning, in addition to getting paid.
Right. That never hurts, right?
That doesn't hurt.
Matt, your thoughts. And I know we're at time. We'll go just a little bit long, give to each the other two the opportunity to comment on that.
One of the things that I mentioned before that the GE licensing does is we participate in pools. We like them. I know they're not for everyone in every circumstance, but part and parcel of that is we have to have our patents evaluated by a third party. And so you can go to the patent pool website and you can see the patents that have been evaluated and where in the standard they map. So essentiality should be pretty settled. But of course, it's the licensee's right to have doubts and to challenge whatever we assert. But let's just do that at once. Let's get through that, and then let's move on. And it kind of goes to what Jim was saying earlier about get the lawyers out of the room at some point. Saying that as a lawyer myself. Yeah. Do that challenge. I'm not in the business of licensing invalid patents, so I'm fully for you being comfortable as a future customer, but let's get through that part of the process and move forward. If you just stay in that part of the process, then, are you really a willing licensee?
Yeah, and that's the $64,000 question. I think that nobody wants to really touch. And right before it comes up, the cases have a way of settling. That's my 2 cents. Kurt, your final. You get the last word.
All right.
Your final thought.
Yeah, I just come back to. I understand the implementer's concern. Patents, unlike other forms of intellectual property, they could be invalid. There might not be infringement. There's a lot more that goes into it. You know who wrote Last Dance with Mary Jane. That's Tom Petty's song. There's less concern there. But when it comes to patents, there are a lot of unknowns. But the question it becomes is who should bear the risk of that? And so I just look back at normal contracts. If you hire somebody to plow your driveway for the winter, you don't know how much it's going to snow. You don't know what the price of gas is going to be. Each side has to take on some risk. And what I see from the implementer crowd is saying, no, we need perfect certainty on all of this, and you, the patent owner, should be responsible for proving this. And when it comes to stuff like validity, it's like trying to prove Russell's teapot, if you're familiar with that. But you can't prove a patent is valid until you know every piece of prior art in the world, so it just would never end, right? You can prove it's valid over that reference, but you can't prove it's entirely valid. So this idea that somehow implementers would ever be satisfied if they just had more information, again, it seems it's not about transparency in my mind. It's really about who's supposed to be doing that labor.
Yeah, and I'll just say my last slide. I'm all in favor of 100% information and 100% guaranteeing we got it right, but that has to affect the price, and that's the problem. I think what implementers or not implement, what implementers want is they want, well, we want this and we want this and we want this, and you have to go through all of these different hoops, and then when we get to the end, to have satisfied them with all of the due diligence, for lack of a better way to describe this, that they demand, then they want the price that would have occurred had they required no due diligence at the very beginning 10 or 12 years ago, with now ridiculously inflated dollars.
Well, and not only that, the volumes have probably changed, and the projections are different, and now which could have been future is now past. Right, because it's like now the time's progressed.
Yeah, no, absolutely.
Yeah.
So, Kurt, you will be seeing and hearing your fishing license soundbite on YouTube as soon as I can edit the video. I thought that was brilliant. Thank you very much for that. And thank you for a wonderful panel, everyone. And we're now going to be on break until noon. So please join us for some coffee and some more pastries and yogurts and granola and that sort of thing. So thank you, everyone.